La Cour
Please be seated. I declare open the public hearing on the admissibility and merits in the case of Yasak versus Türkiye. The application was lodged with the court on 2 April 2020 under Article 34 of the Convention by a Turkish national, Mr. Şaban Yasak. The application was allocated to the second section of the court pursuant to Rule 52, paragraph 1 of the Rules of Court. The application was communicated to the government on 19 February 2021. By a judgment of 27 August 2024, a chamber of the second section declared admissible the complaints under Article 3 of the Convention relating to the conditions of detention in Çorum prison and under Article 7 of the Convention, and the remainder of the application inadmissible. It held unanimously that there had been no violation of Articles 3 and 7 of the Convention. On 26 November 2024, the applicant requested that the case be referred to the Grand Chamber in accordance with Article 43 of the Convention. The panel of the Grand Chamber accepted the request on 16 December 2024. There are 3 third-party interveners in this case. First, the United Nations Special Rapporteur on Human Rights and Counterterrorism, Mr. Ban Saul, was invited by the President to make written submissions in accordance with Rule 44, paragraph 3 of the Rules of Court. The European Criminal Bar Association and the Italian Federation for Human Rights sought and were granted leave by the President to make written observations, again in accordance with Rule 44, paragraph 3 of the Rules of Court. The respondent government are represented at this hearing by their co-agent, Mr. Abdullah Aydin, along with Mr. Stefan Talmon and Mr. Olgun Degirmenci, counsel. Also appearing are Ms. Burçin Bayrak Şenoçak, Mr. Nuri Uzun, Mr. Hasan Akjeviz, and Mr. Şenol Taş, advisors. The applicant is represented by Mr. Johan van de Lanotte and Mr. Johan Heymans, counsel. I welcome the representatives on behalf of the court. I also welcome a group of Greek and Japanese judges and legal advisors from the Albanian Constitutional Court who are on a study visit to the court. Having consulted the agent of the government and the representative of the applicant, I have determined the order of addresses as follows. Mr. Abdullah Aydin and Mr. Stefan Talmon for the government will speak first, followed then by Mr. Van de Lanotte and Mr. Heymans for the applicant. So I give the floor to the government side. Please, the floor is yours.
Monsieur le President, honourable members of the court, our government would like to concur with the conclusions of the second chamber, according to which there was no violation of the Convention. We are in full agreement with the findings on fact and the reasoning adopted in the chamber in its August 24 judgment. The government would like to reiterate its observations before the chamber, as well as those observations submitted to the Grand Chamber. Although the applicant also alleges a violation of Article 3, the present case mainly concerns his conviction for membership of an armed terrorist organisation and his allegation according to which this conviction violated Article 7 of the Convention. Our submissions will focus on whether or not the conviction of the applicant met the foreseeability criterion under Article 7. Turning to the allegations of the applicant about the material conditions in the Çorum prison, the government would respectfully invite the court to take into account our detailed written observations. President, honourable members of the court, before Mr. Talman speaks to Article 7, I should like to make a few preliminary remarks. The court will realise that the conviction of the applicant happened in a wider context. The armed terrorist organisation in question is FETÖ PDY. This organisation has been recognised by the Turkish court as being responsible for the violent attempted coup on the 15th of July 2016, during which 251 persons lost their lives and thousands of others were injured. There is no controversy about the fact that trying to overturn a constitutional order in a state by means of force is an act of armed terrorism. Over the years, FETÖ PDY has put in place a parallel structure, namely within the police, the armed forces, the security services and the judiciary, in order to reach its ultimate goal, namely to overturn the constitutional order. This parallel structure and its goals were exposed to the public by, inter alia, the December 2013 events. These events led to investigations into the organisation and its activities being stepped up. Although other individuals have been convicted for membership of this organisation, the present case is not about the classification or the status of the organisation itself, is not about Turkish politics, nor on the judicial system in Turkey in general. The case is about the foreseeability of the applicant's conviction and the decisions taken by domestic courts in his specific case. The government does not accept the applicant's version of events. It does not accept either the so-called estimates found in Annex 11. In particular, the government would like to draw this court's attention to the following points. Throughout his observations, the applicant has tried to minimise his position and his activities. He was not merely a student coordinator for students, tutoring them within the student houses, setting aside what we might understand coordination might mean within houses. He was responsible for the management of these student houses within the organisation, including the selection of the students, the organisation of the programmes, and the management of financial affairs. The applicant affirms that he expressly asked to confront the witnesses, and this was refused each and every time. This is quite simply untrue. The government has provided the minutes of the hearings and the judgments in documents 4 to 6. Neither the applicant nor his counsel asked to cross-examine the witnesses. On the contrary, the testimony of the witnesses were just generally rejected as being abstract in nature. Furthermore, the applicant argues that his conviction was based only on the testimony from 2 witnesses. But as the case file shows, this is demonstrably untrue. 3 other declarations during the investigation were also added to the trial court case file. This confirms that the applicant referred to these declarations in his written and oral observations. These declarations were, and this testimony was taken into account in the judgment, and therefore the trial court expressly based its conviction on the complete case in its entirety. The applicant further alleges that certain new declarations by witnesses were added to the case file by the government at the stage of the procedure before the court, and that the government would have misled your court. This is equally untrue. The applicant presents in Annex 5 an incomplete and warped picture of the situation. The government has observed and sent in letters which show that there were investigative and witness statements added to the file As of May and June 2018, in documents 1418, these observations, this testimony was added to the case file before the Regional Court of Appeal of Samsun, before the latter ruled on appeal on the facts and on points of law. I would also like to indicate that the government objects to the documents provided by FIDU, which reads more like additional submissions than the impartial observations of a third-party intervener. Finally, the government would like to underscore that the court cannot substitute itself for domestic court. It falls first and foremost to the domestic courts to resolve issues around the interpretation and application of domestic legislation. The role of the court is limited to assessing the compatibility with those acts with the Convention. President, honourable members of the court, I would like to thank the court for your attention. President, I would kindly ask you to give the floor to Professor Talman.
Distinguished members of the court, it is an honor to appear once again before you and to do so on behalf of the Republic of Turkey. Article 7 of the Convention, first and foremost, serves as a safeguard against arbitrariness. There was nothing arbitrary in the applicant's conviction. In Yalçın Kaya, the court decided that the offence of membership of an armed terrorist organization was clearly defined in Turkish law. That is, an individual could know from the wording of the relevant provisions, complemented by the case law of the Court of Cassation, what acts would make him criminally liable. The material and mental elements of the offence were clearly defined at the time of the applicant's acts between 2011 and 2014 and have been set out for the court's convenience in the synopsis submitted by the government as document number 1. Let me summarize these elements. On the material side, the defendant must have had an organic relationship with the organization. That is, he must have become part of the hierarchical structure of the organization and made himself available for orders and instructions of the organization. He must have made a material or mental contribution to the organization's actual existence or reinforcement. There is no requirement that a defendant himself used force or committed crimes. On the mental side, the defendant must have acted knowingly and willfully. This means he must have had knowledge of the illegal objectives of the organization and that the organization used or intended to use force to achieve these objectives. The defendant must also have had the will to join the organization on a continuous basis, act within the hierarchical structure of the organization, and contribute to achieving the objectives of the organization. Contrary to the applicant's assertion, there is no specific intent requirement. As the Court of Cassation noted, intent refers to the materialization of the elements in the legal description of the offence willfully and knowingly. Absent a confession, both the material and mental elements of an offence are generally inferred from a defendant's conduct, established by evidence. According to the Court of Cassation's case law, the organic relationship with the armed terrorist organization and that the defendant acted knowingly and willfully within the hierarchical structure of the organization can be inferred from the continuity, diversity, and intensity of the acts attributed to the defendant. The Court of Cassation's approach to establish the material and mental elements of the offense of membership of an armed terrorist organization has been acknowledged by this court in the cases of Demirtas versus Türkiye, number 2, Yüksek versus Türkiye, and Demira versus Türkiye. This approach is not very different from the court's own approach to proof. As spelled out in Ukraine and the Netherlands versus Russia, I quote, "Proof may follow from the coexistence of sufficiently strong, clear, and concordant inferences or of similar unrebutted presumptions of fact." Establishing the material and mental elements of the offense by inferences from the continuity, diversity, and intensity of the acts attributed to the defendant is not arbitrary, and in the light of the established case law of the Court of Cassation, was clearly foreseeable. FETÖ, PDY, was of course not the first armed terrorist organization before the Turkish courts. In March 2016, the Venice Commission adopted a report that dealt inter alia with Article 314, paragraph 2 of the Turkish Criminal Code and the question of membership of an armed organization. The government has submitted the relevant parts of the report as document number 20. In paragraph 100 of the report, the Venice Commission noted, I quote, "There is a rich case law of the Court of Cassation in which the High Court developed the criterion of membership in an armed organization. The Court of Cassation examined different acts of the suspect concerned, taking account of their continuity, diversity, and intensity, in order to see whether those acts prove that the suspect has any organic relationship with the organization, or whether his or her acts may be considered as committed knowingly and willfully within the hierarchical structure of the organization." End of quote. Of the 10 cases the Venice Commission referred to in order to illustrate the rich case law of the Court of Cassation, 9 were decided before November 2013, the large majority between 2007 and 2012. Their continuity, diversity, and intensity included acquiring a code name, giving courses on the aims and structure of the organization, and driving newcomers willing to become members of the organization to the camping place of the organization. All acts that as such are not unlawful. The applicant is thus barking up the wrong tree when he claims that he was convicted for lawful activities. A distinction must be made between the criminal offense, here membership of an armed terrorist organization, and the lawful or unlawful acts attributable to a person that may be used to prove the elements of the criminal offense. In order to illustrate the established case law of the Court of Cassation, the government has submitted as documents number 21 to 25 several decisions rendered prior to 2014, where the Court of Cassation upheld the inference of the material and mental elements of the offense of membership of an armed terrorist organization from the continuity, diversity, and intensity of the acts attributed to the defendants. Of particular relevance to the present case are the decisions in documents number 24 and 25, where the Court of Cassation based the conviction inter alia on the use of code names. Taking into consideration the position of the accused within the organization was also nothing novel in order to establish the elements of the offense. As seen by the decision submitted as document number 26, the Court of Cassation upheld a decision of May 2013 in which persons were convicted for membership of a terrorist organization on the basis, I quote, their roles within a student association which was operating under legal disguise within the scope of actions of the youth wing of the PKK terrorist organization. The Venice Commission did not call into question or criticize the Court of Cassation's approach to use the established criteria of continuity, diversity, and intensity of acts attributable to a defendant in order to show his organic relationship with the organization and prove that he acted knowingly and willfully. It only recommended that the criteria be applied strictly. It is the government's submission that in the applicant's case, the criteria were applied strictly. In contrast to the court's finding in Yalçın-Kaya, the domestic courts did not just use one act on its own as conclusive proof of the material and mental elements of the offense. The difference between the two cases is clearly illustrated by the table comparing the acts attributed to the accused. The table is document number 3. As can be seen from another table submitted as document number 2, in the present case, 8 different acts could be attributed to the applicant on the basis of a wide range of evidence. These acts stretched over more than 4 years, and over these 4 years, the applicant's relationship with the organization became ever more intense. From just living in one of the houses of the organization to managing more than 20 of these houses, adopting a code name, and finally becoming responsible for several thousand students living in the state dormitories in Çorum province, while at the same time working for a company affiliated with the organization. In his observations, the applicant focuses on individual acts in isolation in an attempt to show that each, on its own, cannot establish the constituent elements of the offense. Such an approach, however, is divorced from reality and judicial practice. In its decision, which has been submitted as document number 6, the Çorum Assize Court emphasized that it was necessary to consider all the activities individually, and I quote, and as a whole. And it is submitted in the context of the general knowledge about the terrorist organization in question. The applicant focuses in particular on 2 individual acts: the position as BBTM and the use of a code name, in order to create the misleading impression that he was convicted solely on the basis of these 2 acts on their own. and that there was some kind of automaticity between these acts and his conviction. Nothing could be further from the truth. The domestic court established the constituent elements of the offense in an individualized manner. There was no automatic presumption of guilt based on the position of BBTM or the use of a code name. The applicant could have exonerated himself from the allegations, but he chose not to do so. On the contrary, he denied any relationship with the terrorist organization despite clear and overwhelming evidence to the contrary. The applicant's conviction was by no means based solely on his position as BBTM. The Assize Court took account of the fact that over the years, the applicant held 4 different positions, regularly being promoted and rising through the ranks until he finally reached the position of Ilchi in 2013 and 2014. That is, the person responsible for several thousand students living in state dormitories. The applicant tries to downplay his position and activities within the student organization of FETE PDY, concealing that student recruitment and fostering played an important role in the overall strategy of the organization to overthrow the constitutional order. Contrary to the applicant's allegations, there was nothing automatic between his position and the conviction for membership of an armed terrorist organization. In the decisions submitted as documents number 28 and 29, the accused was acquitted, despite being a BTM like the applicant. But unlike the applicant, the accused did not use a code name, did not engage in organizational activity after the December 2013 events, did not have a bank account with Bank Asia, and did not have any employment with the FETE PDY affiliated entity. It is thus not the single act of holding a certain position, but the continuity, diversity, and intensity of the acts that helped to establish the constituent elements of the offense. The applicant also tries to call into question the use of code names as proof to establish the constituent elements of the offense, alleging, without providing any evidence, that the use of code names was a tradition practiced by several religious groups in Turkey. This is refuted by the letter of the High Board of Religious Affairs submitted as document number 19, and the fact that the use of code names served as a basis for conviction for the offense of membership of an armed terrorist organization, as seen by the decisions submitted as documents number 24 and 25. The Assize Court convicted the applicant not on the basis of the 2 acts, but on the basis of the, I quote, entire case file as a whole. As set out in the table in document number 2, the case file includes 8 different acts, including the applicant depositing, upon instructions, money with Bank Asia. Unlike in the Alçınkaya case, the Çorum Assize Court used the applicant's exceptional deposits in his Bank Asia account as substantial evidence, not in the sense that it could prove membership on its own, but as one of several acts proving organizational activity. This finding was reached not just on the basis of the deposits as such, but also on the basis of the applicant falsely claiming that the money in question was transferred to his account as his salary, while the bank records clearly showed that the deposits were made with the applicant's bank card via a cash machine after the leader of the organization had instructed members to make deposits. The applicant claims that in the present case, the mental elements of the offense were not established because in 2014, no one could have been aware of the terrorist nature of FETÖ PDY, and therefore its characterization as an armed terrorist organization was not foreseeable. The question, however, is not about general foreseeability, but whether the characterization was foreseeable for a person with the applicant's position within the organization. The applicant is simply wrong when he claims that for the presence of the mental elements, he would have had to know that a coup was coming, or that legally there can be no armed terrorist organization before the first violent act. There is no support for such claims in Turkish law or in the court's own case law. On the contrary, as the court held in Yalçınkaya, the fact that FETÖ PDY had not yet been classified as an armed terrorist organization when the applicant carried out the various acts does not preclude the criminal liability of members of the organization for acts undertaken before such classification, to the extent that they acted knowingly and willfully. In line with the established case law of the Court of Cassation, the Çorum Assize Court established on the basis of the diversity, continuity, and intensity of the acts attributed to the applicant that he was acting knowingly and willfully within the hierarchical structure of the organization. Members of FETÖ PDY in the applicant's position would have known about the nature of the organization long before this nature became known to the general public. In any case, the organization's terrorist nature became generally known after the events of December 2013. As the Constitutional Court noted in the Adnan Sen case, many investigations regarding the organization and its activities were carried out especially after 2013. This was implicitly confirmed by the applicant in his submissions to the Chamber in the present case, where he claimed that he had left work with the FETÖ PDY affiliated company following the December 2013 investigations upon, I quote, the request of his family. For establishing the mental elements of the offense, it is of relevance that the applicant did not leave the organization after its terrorist nature had become known to the general public, but continued to perform his organizational activities as ilçi and continued to work for a FETÖ PDY affiliated company. The Çorum Assize Court also put particular emphasis on the fact that the applicant made the deposits in Bank Asia upon the instructions of the FETÖ PDY leader after December 2013. In addition, the fact that the applicant claimed that he had nothing to do with the organization in the face of the overwhelming evidence to the contrary will also have been taken when establishing the mental elements of the offence.
Mr. Thalmann, I have to inform you that the government side has spoken more than 30 minutes already, so I would kindly ask you to wrap up.
Thank you, Mr. President. Let me, so to speak, conclude. In light of the entire case file as a whole, the applicant's conviction by the Durham Assize Court on the ground that I quote, "The applicant's acts and activities which involved diversity, continuity and intensity attained the level of membership of a terrorist organization, was in no way arbitrary, and in light of the established case law of the Court of Cassation, was clearly foreseeable. There is thus no violation of Article 7 of the Convention, and the application should therefore be rejected." I thank the Court for your kind attention.
Thank you very much. I thank the government side for their pleadings. Before giving the floor to the applicant side, let me remind the public attending this hearing in the main hearing room, please put your mobile phones and other electronic devices to silent and don't use them during this hearing, not to disturb this audience, this hearing. So I turn now to the applicant side and give you the floor. Please, the floor is yours.
Dear President, dear distinguished judges of the Grand Chamber, my name is Johan Heijmans, and I appear before you today together with my colleague, Professor Johan van der Lanotte, to speak for Mr. Yasak. Today, we come here in sorrow. In 2023, we stood in this court in the ECtHR case, and we left with hope. Hope that the powerful judgment that your court rendered would restore the rule of law in Turkey and protect the rights of those persecuted without cause. But we were wrong. Turkey did not comply with your court's judgment. On the contrary, the Second Chamber's judgment in this Yasak case is now used by the Turkish courts to justify the same violations your court already condemned in the ECtHR case. And that is why this case is so critical. And that is why so much is at stake. Until now, 150,000 people, teachers, nurses, students, ordinary citizens, were convicted for membership of a terrorist organization. And last year, even 14-year-old girls were put on trial for the same reason. And all these victims have placed their hopes in your court to put an end to this dangerous tendency, a tendency that goes beyond Turkey. As the United Nations Special Rapporteur Ben Saul in his third-party submissions explained, anti-terrorism laws are used, or better abused, to silence dissenting opinions. This results in terrorism no longer being defined by a violent or criminal intent, but by association. And the mere fact that one has some kind of connection to an organization which arbitrarily and a posteriori is qualified to be a terrorist organization automatically results in them being convicted for terrorism. And that is unacceptable. And that is what we will demonstrate to your court today and what is explained in our submissions. As to our pleadings, my colleague will first focus on the factual aspect of foreseeability under the Article 7 of your convention and thus address the questions 2, 3 and 4, the first part of the questions your court asked. And then I will return to address the legal aspect of foreseeability and thus the questions 4, the second part, 5 and 6. Due to the time constraints and similar to the government, we refer to our written submissions regarding question 1 and the violations under Article 3 of the Convention. However, first an important preliminary remark on the Second Chamber's decision of your court. To us it is clear that the Second Chamber was misled, factually speaking, by the documents presented to them, and which led to an unjust legal conclusion. As demonstrated in our Annex 3, at least 6 paragraphs in the second chamber's judgment misrepresent either the indictment or the decision of the domestic courts. Terms such as clandestine, secret, recruiting, which was also cited by the government a moment ago, appear in the second chamber's decision, while these words are nowhere to be found in the actual indictment or the decisions of the domestic court. Even more troubling is the fact that documents which were never part of the original case file continue to be added to this file by the government. It happened both before the second chamber and now also before your court. And for instance, we are now confronted with a new report of the HTS about the phone contacts and new witness statements which were not even part of the original case file and of which the domestic courts were not even aware when taking their decisions. Likewise, important factual points are not correctly presented in the government's submissions. We note, for instance, that the citations of Mr. Gullen, which should allegedly indicate or prove his intent to incite people to commit violence or terrorism, date in reality from before 2000 and were already part of the trial which was held against Mr. Gullen in 2008 and in which he was acquitted of any wrongdoing by the Turkish courts. Similarly, the government continues to refer to, for instance, the witness statement of BA, which would be, according to them, a crucial witness statement, while that was not one of the conclusive points of evidence which was taken into account by the domestic courts to come to a violation or to come to a conviction. We therefore urge the Grand Chamber to exclusively focus on the facts and the original documents as used by the domestic courts and not rely on the government's post hoc reinterpretations of original documents and not rely on the additional documents that were never tested at trial, but which are now joined to this case file. I will now pass the floor to my colleague.
Thank you, Mr. President, dear distinguished members of the court. I will address your court now on the second question, basically about the factual foreseeability. The Turkish jurisprudence makes a slight distinction between the period before 2014, and we heard that from the government side already today, and from 2014 on. They call it the milestone moment. It's the term used by the Court of Cassation. I will comment first the period before 2014. After years of prosecution, the Gülen movement indeed gradually developed an excellent network of educational institutions who attracted many students. For instance, the former Minister of Finance and son-in-law of President Erdogan was a student at the Gülen Institution, and the son of the former Minister of Justice, who stayed 2.5 years, 2010 to 2012, in a student house of the Gülen movement, notably the same period, but not the same city, but the same period Mr. Yasak was studying also. The governmental support to the Gülen movement was clear, with statements of high-level members of government and of the president itself. Also, the acquittal already cited by my colleague of Mr. Gülen in 2008 must be mentioned. These elements lead, and actually are not completely contradicted by the government, all these elements lead to the conclusion that until the end of 2013, no member of the Gülen movement, no Turkish citizen, no member of the government, nor a member of the judiciary was considering the possibility of the Gülen movement being designated as a terrorist organization. The situation changed following the judicial corruption investigations in late December 2013 and the judicial actions, 2 times judicial actions, regarding the supply of weapons by the Turkish Secret Service in January 2014. The government qualifies this as a judicial coup, which makes it clear that the Gülen movement was a terrorist organization. We fundamentally, and not we alone, we refer to our written observations, we fundamentally contest this characterization of a judicial coup. It must be the first time in world history, and it's a bad example, that judicial actions against the government are qualified as terrorism and anyhow not in accordance with any legal disposition concerning terrorism. It is completely unacceptable that this action of prosecutors and judges should have obliged the members of the Gülen movement to consider their legal and publicly known activities as organizing institutions for students, that they should consider their legal and public known activities as terrorism. Nevertheless, the government states that from beginning 2014 onwards, every person linked to the Gülen movement had to know that the aim of the Gülen movement was to overthrow with violence the existing constitutional order of Turkey and had to take distance from the movement. Nevertheless, any activity within the Gülen movement from 2014 on leads, according to the jurisprudence, to the suspicion and the supposition of being a member of a terrorist organization. From the acts, a deduction automatically comes that you're a member of the terrorist organization, and with the motivation you should have known there were two judicial actions, actions of judges, prosecutors, and this should have convinced you that what you're legally doing is part of a terrorist organization. The government also invokes, as a convincing element, the statements of the National Security Council, which, according to the government, qualified the Gülen movement from 2014 on as a terrorist organization. I want to make several remarks on that topic. First, the reports of this National Security Council do not mention, as we made clear in our observation, do not mention terrorism until 30 May 2016, not earlier, as confirmed in the Yasin-Kaya judgment, paragraph 251. Mr. Bülent Arınç, at that time minister and member of the National Security Council, confirms this clearly, explicitly. Mr. Ahmet Davutoglu, at that time Minister of Foreign Affairs, rejected in 2014 still allegations against the school and said he supported the schools. In the Özdemir judgment, paragraph 40 of your court, it is confirmed that in 2015, the nature of the organization was still, I quote, discussed. And the Council of Europe Commission for Human Rights stated that the readiness to use violence, I quote, had not become apparent to Turkish society until the coup attempt. However, there's a more fundamental remark. The National Security Council is part of the executive branch. It's composed of the president, of ministers, and army commanders, and has no binding legal power. Is it thinkable in our democratic system that in a country the government simply decides without at that time any presence of violence, without at that time no indication of violence, unless we see a judicial action as violence? I hope you do not. But that an executive branch decides that an organization not using violence, not tend to be and conceived to be using violence, that this organization is qualified as a terrorist organization, and that every citizen ipso facto, immediately is supposed to act accordingly. So the government in January 2014 thinks and states, it is a state, but let's say we accept for one time that it already in January 2014 would have said, which is thus in 2016, and immediately 2014, someone who is employed has to quit his job. He cannot see any people anymore or whatever. I will refer to another case. The Gezi protesters, and Mr. Kavala, well known to your court, were labeled to be looters and terrorists. Did every Turkish citizen then have to accept that and abstain from protest? Is that our conclusion? I don't think so. It's obvious even that such a reason that an executive branch can, without due process, decide this is an organization with terrorist aim, that as a result, everyone has immediately to accept and change his behavior on sanction that afterwards he will be punished with prison for 6 years and 3 months, what is the usual punishment. That is completely against the basic elements of the rule of law in a democratic society. The fact that the National Security Council has qualified the Gülen movement as a terrorist organization does not imply that these statements are the truth and that the citizens have to accept that immediately and act accordingly without any due process, without any fair trial, without any system that protects them for an arbitrary decision on that level. At least until the failed coup attempt, there is no serious argument, as the Council of Europe Commissioner said, that that an active member of the Gülen movement could and had to foresee that this movement would be qualified by criminal courts as a terrorist organization. And I think it's important that is clearly said. I will now go deeper in the specific allegations against Mr. Yasak. The court decision has 5, not 8 or 9, as the government says. There is no question of collection of money in the decision. In the witness statement, it is even said that he did not collect money, literally, explicitly. There is not said in the court decision that he inquired about students in order to promote to house imams. This is in a witness statement that is taken afterwards and is not taken into account by the Çorum court. It is not stated that in the decision that he was sent to Ankara on orders of the organization. This is part of a witness statement that not had been taken by the Çorum court. And most of all, it is not true. Mr. Yasak left in June. He went to Ankara. He went to study there, and he changed to another religious community where he stayed. If this had been brought up by the court in Çorum, it would have been contradicted. But now it's again brought. It's not in the decision of the Çorum. And the traveling to Kosovo is not in the Çorum decision. He is convicted for 5 elements. 5. Not 8, not 9, 5. We go back. First of all, because he was a BBTM, a greater regional coordinator. That's it. The ILCI is not mentioned in the dictum of the court decision, is not named. The dictum, he said he was a BBTM. Greater regional student sounds big, of course. That means he was responsible for 100 students. At that time, the Gülen movement had houses for 200,000 students. This means 100 with Mr. Yasak. That is 0.005% of the students were under his tutoring while he was student. And that is called hierarchical. I don't see what is hierarchical to tutoring as a student 100 other students. When you know that the organization has 200,000, other students. But we should not be surprised. that is argued like this. Until now, as my colleague said, 150,000 persons are convicted for membership of what they call veto. This means, according to the jurisprudence, because otherwise you cannot be convicted, that these persons are considered to be at a hierarchical level. More concrete, 150,000 persons knew that a coup was prepared and were willing to help. That is the logic conclusion if 150,000 persons are convicted on the basis just exposed. There is no country where 150,000 people can prepare a coup and no one knows. I'm a Belgian citizen and surrealism is part of our identity. We are used to some surrealism, but this gone beyond, even for a Belgian citizen. This is not surrealistic. It is irrealistic. It is fabricated. It's doctored, with the only goal to clean the society from an organization, once an ally and now an opponent. A judicial practice leading to the conviction of 150,000 persons, which is the practice used against our clients, assuming they all were preparing a violent overtake of the government, left aside of the legal deficiencies which my colleague will explore and comment, is unacceptable. And it cannot lead to the conclusion that Mr. Yasak in 2013 and 14 had to take all these elements in account by deciding if he would stay working, if he would stay studying, if he would stay tutoring students. Next to the BBTM, the other is the HTS report, the communication. My colleague already mentioned there is a new, presented to your court, a new HTS report, which has never been, it's in the annex, it has never been proposed to Mr. Yasak. But it is interesting. It is interesting because the court, the second part of the conviction is communications with EB. It's also in the synopsis of the government. He had communications with EB. In this report, you can find that he had two communications. Two with EB, which he accepted in his declaration. Two, namely, on 16 July 2013 and 31 August 2013. These are the two communications in the report submitted after the conviction, so never given to our client, but 2 times EB. And that is based to say he had contacts with the responsible people of the organization. It was a colleague of him, and he called him before he entered into service of that school. Thirdly, the deposit of money. I hear say exceptional deposit. He had this account for long. He deposited money in January and February, and he used this for his daily affairs. Why he deposited in January or February? Because while he started working in December, the first payment received only end of February. What is never mentioned is that when he stopped, he was his last payment in October, and he stopped, he closed the account in November. Finally, we have the code name. To be honest, I am not very impressed by the declaration of the president of DNet organization who, within 8 hours after the coup, declared that the Gulen movement was responsible. So we cannot expect that DNet, who said that they are terrorists, now will say that they are not terrorists. I'm not impressed by that declaration. We explained in the report the understandable fear from the Gulen movement for prosecution. I will simply read what the special rapporteur said. A factor such as participation in secret activities by a group is not necessarily indicative of wrongdoing or knowledge of the group's terrorist purpose, particularly in states where freedom of political, religious and other expression are limited in a manner inconsistent with human rights law, and secrecy aims to avoid unjustifiable criminal repression. Simply said, being suspicious or being afraid of prosecution does not mean you're a terrorist. Yesterday morning, 208 persons were detained in 47 provinces. The official press statement mentions as one of the elements of suspicion training camps abroad. What does that mean? That means participation in Erasmus programs. Unfortunately, we should not be surprised. I would like to finish my pleading asking the court to have a look at Annex 6, pages 21-24. A group of police officers, judges, professors, prosecutors, members of parliament, civil servants, all different branches, mixed, established the fetometer, enumerating 10 facts that should lead to a person to be considered as a terrorist, without one word about intent or about knowledge. And that's for my...
Dear President, distinguished judges of the Grand Chamber, I will now turn to the lack of legal foreseeability of the crimes Mr. Yasak was convicted for. Under question 4, your court asked whether the interpretation and the application of Article 314 of the Turkish Criminal Code, which defines what is an armed terrorist organization in Turkey, evolved in a foreseeable manner. And the answer is clearly no. Until 2016, Turkish courts consistently held that violence, or at least a clear intent to use violence, was a core element of terrorist membership. And that principle was in line with international standards. But after 2016, that radically changed. Suddenly, it became sufficient for an individual to be merely associated with the Gülen movement, regardless of whether they had engaged or even supported any violent or criminal acts. Furthermore, since 2017, the Turkish Court of Cassation introduced a whole lot of new legal concepts. So we have heard a lot of references to old jurisprudence, but a lot of new concepts were introduced in 2017, new legal fictions, which furthered this legal uncertainty. It labeled the Gülen movement as a sui generis terrorist organization. The defining features of terrorism, violence and weapons, were discarded. Instead, mere membership of a lawful organization, or even the fact that you had some kind of proximity to a person that was alleged to be part of the Gülen movement, was suddenly sufficient to be convicted for terrorism. The layered hierarchical structure doctrine, which was introduced in 2017, exemplifies this shift. These 7 so-called layers of hierarchy, they were created out of whole cloth by the judiciary. They do not provide any objective criteria to determine in which layer you would belong. There is no meaningful defense, consequently, that could be held against such classification. And these layers transformed what were once legal activities, teaching, studying, or even tutoring, into retroactive indicators of terrorism. And that's what happened to Mr. Yasak. He was convicted for tutoring students. There is no evidence that these students were involved in any violence or of any crime, or even worse, in the alleged coup. And neither was it ever examined by the Turkish authorities, which would have been crucial. More importantly, is that the Turkish courts have forgotten, or seem to have forgotten, about the basic principles of criminal law, notably that crimes should be individualized. A teacher, a doctor, a student, they all could suddenly be held criminally liable because someone, somewhere in the Gülen movement, would have been part of the army and would have consequently had access to weapons. That's the position that the government takes, and that leads to collective guilt, which replaces individual criminal responsibility. And that is unacceptable in light of foreseeability. Similarly and crucially, the domestic courts no longer inquired into the intent of the accused. And this is clearly demonstrated by the Annex 1, which the government submits to your court. It lists all the acts which would be indicative of the alleged terrorist activities of Mr. Yasak, but it says nothing about the mental element, about his state of mind. While when one looks at the testimonies in the case, all the witnesses say that they were completely unaware of the fact that the Gülen movement would have had any terrorist objective or aim. And the same is true for Mr. Yasak. He was completely unaware if that would have even been the case. So intent is merely presumed, and this leads, as your court already stated in the Yalçın-Kaya case, to an almost automatic presumption of guilt. The government wants to stress the difference with the Yalçın-Kaya case by stating that it concerns different facts and that now they rely on more factual elements. But in reality, it concerns, in its essence, the same problem. In both cases, the domestic courts did not investigate the intent. They did not individually and specifically examine the mental element. And that's the problem. What we are witnessing is a fundamental breakdown of legality. The mental element, dolus directus, under Turkish law, requires proof that the accused knew of the group's objectives, violent aims, and deliberately sought to further them. But since 2017, this has been replaced by a presumption. Once you had a certain level of education or a certain hierarchical position, one should have known that the organization was a terrorist organization. There is no assessment of an individual's knowledge, no inquiry into their will. The burden of proof is inverted, guilt is assumed. Even more troubling is the retroactive criminalization. Lawful conduct, opening a bank account, tutoring students, working for the Quorum Educational Services, which was a legally established and inspected organization, was suddenly reinterpreted after the fact as being criminal. And even in the Saçmaz decision, the Turkish Constitutional Court concluded to a violation of legal foreseeability. The Turkish jurisprudence has not evolved in its essence, because both the Constitutional Court and the Court of Cassation in Turkey continue to accept that people are convicted for being a member of a terrorist organization without individually inquiring into the intent, into the mindset of the accused. Dear President, dear distinguished judges of the Grand Chamber, foreseeability is the cornerstone of legal certainty. But when definitions are invented ex post facto, when guilt is presumed, when there is no inquiry into the mental elements, and when lawful behavior is criminalized retroactively, the law becomes arbitrary. And that is exactly what happened with Article 314 of the Turkish Criminal Code, as applied specifically with regards to the Gülen movement. This is not justice, it is not law, and it is certainly not foreseeable. And we therefore, and in line with our submissions, respectfully request your court to come to a conclusion that there is a violation of Articles 3 and 7 of the Convention. We request your court to come to a firm decision in which these violations are condemned, but more importantly, in which clarity is brought, clarity to make sure that the Turkish judiciary can move towards a clear and foreseeable legal framework. And that is missing at this moment. And Mr. Yasak's case is a very clear example of that situation. We thank you.
Thank you for your submissions. Now I invite the members of the Grand Chamber who so wish to put questions to the parties, starting with Judge Yüksel, please.
Thank you, Mr. President. I have one factual question for the applicant. The other party government can, of course, also comment if they wish so. Before the domestic courts, the applicant stated that, and I quote, "I have not taken on any responsibility as a BBTM within the organization or anywhere else, and I've never used a code name contrary to the allegations of the witnesses." On the same line, before the appeal court and the Court of Cassation, he argued, and I quote, "The witness assertion that the accused is the principal regional coordinator BBTM is unfounded accusation and lacks any evidentiary basis. Then before the chamber, in his observations, the applicant, without providing an explanation regarding the use of code name or his role as BBTM, submitted that, here I also quote, the applicant admitted having been accommodated in the organization house. However, he denied having performed high-level activities such as house imam, district imam, regional imam, provincial, etc. Then in his written observations to the Grand Chamber, the applicant accepted that the evaluation made by the Grand Chamber must take into account the factual basis as decided by the domestic courts. And the applicant then proceeds to give explanations regarding the activities attributed to him, in particular the use of code name and his function as a BBTM, specifying that, I quote, all these functions were executed on a voluntary basis while he was completing his own undergrad studies. So my question is the following. How would you explain these differing positions taken over the course of the proceedings domestically and then before this court? Thank you.
Thank you very much. Followed by Judge Nii Rafferty, please.
Thank you, President, and thank you to the various contributors so far. I have a number of questions for both sides. Unfortunately, they number 6 at this point on each side, but they cover much of the same territory, and it may be of some comfort to know that it may prevent other judges having to ask many questions. It may also be possible to provide you with a written version of at least the essence of these questions at the conclusion of this. So, to the applicant, first of all, and may I preface this by saying a lot has been said about the wider context, and while, of course, that is important, we need to focus on the particular case in hand, and these questions are directed at events in this case primarily. The first question to the applicant is, do you accept that you did not raise Article 30 of the Criminal Code expressly or in substance in the domestic courts? Question 2. Before the trial court, the assize court, your position was that the witnesses were lying and that you had very little connection with the organisation other than minimal connections. Your arguments now to the Grand Chamber might be considered to implicitly accept that you were a BBTM within the organisation. Should the Grand Chamber now proceed on the basis that you were a BBTM, or is this fact still disputed? Similarly, do you still dispute that you used a code name? If you do dispute it, what is the relevance of the evidence you submitted in relation to the use of code names in Turkish religious organisations, if your position is that you did not use one anyway? 3, do you accept that you did not raise the issue of foreseeability or mens rea specifically in the domestic courts? 4, in your observations you make many arguments. One of them is that the characterization of the organisation FETA PDY as a terrorist organisation always was and continues to be incorrect, mistaken, wrong. Why are you making this case when your defence in the domestic courts was that there was little or no link between you and the organisation? Why today are we hearing so much about the Gulen movement generally and all the other cases not involving you? 5, can you explain where you get your figures from in relation to the numbers of BBTMs in Turkey? Finally, arising from the oral hearing today, 6, do you accept that in Turkish procedural or evidential law, witness statements taken by the police and on the case file are evidence, even if the witness did not give oral evidence to any court. I'll repeat that. Do you accept that witness statements taken during the investigation, which are on the case file before the court, but where the witness did not give evidence to any court, constitute evidence? And similarly, in Turkish law, do you say that documents which come in after the conviction but are before the appeal court can be taken into account by the appeal court? So there's considerable overlap to the government. Questions 1 to 6 are 1, regarding Article 30 of the Criminal Code, does an accused person have to expressly invoke it, or is it sufficient if it's raised in substance? 2, Article 30, which is the mistake provision in the Criminal Code, appears to require an accused person in the context of a membership case to show that he did not have knowledge of the violent or potentially violent nature of the organisation. How does this work in practical terms? I will confess that I spent much of my life at trials in criminal courts, so I'd like to know how this works in practical terms. What kind of evidence is used? And in particular, does an accused always have to give evidence himself about his lack of knowledge for Article 30 to come into play? 3, what is the relationship legally between Article 30 and the Court of Cassation 7 layers approach as described in their judgment of 26 September 2017? The Court of Cassation said the upper layers must be taken to have knowledge of the true nature of the organisation. Does that mean that Article 30 simply does not apply to those upper layers? 4, in that context, can you please confirm what layer specifically the position of BBTM is said to fall on? 5, concerning the number of BBTMs in Turkey, in your written observations, you comment that the figure given by the applicant, repeated today 150,000, does not come from a reliable source. Is that all you wish to say about this figure? And finally, 6, the same question about witness statements. Can you confirm that witness statements which were taken during the investigation but where the witness did not give oral evidence are treated as evidence by the court? And what is the status if documents, witness statements, HTS reports come in after the conviction but before the appeal is concluded? Can that be taken into account by the appeal court? That's a procedural question as to the evidential status of the documents. Thank you. And thank you, President, for the patience of all the court.
Thank you very much. Judge New Rafferty, followed by Judge Guillaumard.
Merci, monsieur. J'ai une question. Oui.
We can hear me now. Thank you very much. I would have a question that I would like to address to the representatives of the government, but of course the representatives of the applicant are free to answer that question if they wish to do so. You have indicated in your pleadings before the court this morning the elements that are constitutive of a criminal offence that is provided for in Article 314 of the Code, and you've mentioned the criteria of continuity, diversity, and intensity. And then, if I understood you correctly, you made a distinction between this criminal offence that I have just described and possible legal acts that could be attributable to an individual, the perpetration of which if I've understood correctly, if taken as a whole in a certain context, could make it possible to characterize the criminal offense. Here comes my question. With regards to the 8 different acts imputable to the applicants, if I'm not mistaken, what is your position with regards to each and every one of these acts? Are they all lawful, legal in and of themselves? Are some of them illegal? And if so, on which basis are they deemed to be illegal? And supposing that each or every one of these acts attributable to the applicant and which serve to qualify the criminal offense of Article 314, and I refer you to the ECtHR judgment, paragraphs 253 and 254 and 270 and 271 paragraphs of the judgment, how you do reconcile that with the demand of foreseeability, to which is attached the absence of objective responsibility. You need to individually characterize the moral element of an offence for that to be established. Many thanks to Judge Guillaumard. We'll listen to President of Section, Judge Tsitakis.
I have one question for both parties under the claim of Article 3. I want to know what is the position of the parties about the duration of the detention in Unit F5 of the applicant, and if he was forced to sleep on a mattress on the floor, and for how long. And my last point on the same claim, about the same claim, is if during his detention in this Unit F5, he was forced to sleep in the unit communal living area in which the light was always on during the whole detention of the applicant. Thank you.
Thank you very much, Section President Tistakis. Now I turn to Vice President Jelic. It does not appear to be working. Are there any microphones that are turned in apart from mine? It appears that we have a technical issue. The microphone of Section President Tistakis cannot be turned off. Is there...
Okay, so I hope now it's working.
Yes. Yeah? Okay. Vice President Jelic, please.
Can you just turn it off?
Should I'm trying.
Now, I think your microphone is on.
Okay, so my mic is on now. I would like to thank to both parties for their contributions. I have two questions for both parties, and I would appreciate it, the applicant and government reply to those questions. So my first question relates to the intent requirement of the offence of membership of an armed terrorist organization. National courts appear to have established this element in the applicant's case based on evidence including his position in the organization, the payment of his social security contributions by a company affiliated with the organization, his contact with members of the organization, and payment he made to a bank affiliated with the organization in a certain period. Can you please clarify first the legality of the activities engaged in by the applicant, and second, whether it can be considered foreseeable for participation in legal activities to establish intent for a criminal offence? My second question relates to the reputation of the organization concerned at the time of the applicant's involvement. I insist on the time of his involvement. It appears that the applicant engaged in organizational activities between 2010 and 2014, well before the attempted coup d'etat of July 15, 2016, and before the organization had been classified as an armed terrorist organization by domestic courts. It should also be noted that the organization concerned had a reputation for many years before as a religious group supported by a significant part of the population in Turkey. The court has not been presented with direct evidence that the applicant knew of the organization's violent objectives at the time of his involvement. Under these circumstances, how could the applicant reasonably be considered to have knowingly and willingly participated in the activities of a terrorist organization by his acts that took place before the organization's true nature was known? Thank you.
Thank you very much, Vice President Jelic. Judge Felici. Again, we have a technical problem.
Okay, now I think it's work.
Okay,
okay,
it appears to be working now. We apologize for any inconvenience in this respect. Please, Judge Felici.
My question followed the one made by Judge Kikakis. Once you have clarified this factual situation, I'm talking about the claim under Article 3, could you please elaborate about the reaching or not of the threshold required by the same article for degrading and inhuman treatments? I will be more precise. I only ask the applicant to reply on the submission made by the government in the written observation 24 February 2015, according to which the elements put forward as to have to lead to a finding of no violation and vice versa. I ask the government, please, to elaborate specifically, to reply about this written submission of the applicant, according to which there is room for a finding of violation. Just precise on these 2 points as a reply. Thank you so much.
Thank you so much, Judge Felici, followed by Judge Seibert-Foer.
Thank you very much, Mr. President. And my question is turned to both parties. I would like to turn to the difference between the actus reus and the mens rea. The government's counsel, as also stipulated by Section President Guillaumard, has stated that there is a need to distinguish between the crime and the acts attributed to a person in order to prove the crime. Now, my question is, to what extent can the acts which are considered to be constituted of an actus reus at the same point of time be considered proof of the mens rea? I'm asking this question because I'm asking myself, in this particular case, was there a difference between the acts attributable to the applicant, which went beyond the actus reus, taking into account that a certain threshold is needed in order to prove the membership in a terrorist organization? And I would also like to know, how can this be reconciled with the court's jurisprudence in GIEM versus Italy, that the guilt concept requires a mental link, according to Article 7. I would also like to stress that over here we are confronted with a crime where, as stipulated by both parties, there is no need to have any kind of violence being involved. So I was asking myself, to what extent is it necessary to pay particular kind of attention to the establishment of the mens rea in this context in order to show the previsibility? Thank you.
Thank you very much. Any further requests for questions? Yes, Judge Jurovic, please. It appears that you have to wait. You push the button and you wait for some time and then it comes.
Yes, it works now. Thank you. Thank you, Mr. President.
Okay. Patience is important, apparently.
Yes, patience. I would have a question both to the government, to the applicant, in relation, again, continuation of the question in relation to Article 3, alleged allegation, regarding the conditions of detention in your own prison, especially in the context of the number of people being detained, and we were provided with some information in relation to the kind of supply, let's say, of hot water, cold water, and other necessary elements for daily life. So could you please tell us how this has been kind of addressed during the stay in prison of Mr. Yasak? Thank you.
Thank you very much, Judge Đurović. Any further requests for questions? Now, this does not appear to be the case apart from my side. I have a question for both parties. Namely, first, according to my understanding, the Turkish law requires that the following elements of the offence be established in cases such as the applicant's, namely, first, the existence of membership in a criminal organization with all its elements. Further, that this organization be engaged or plans to engage in terrorist activities, and that this organization be armed. And I stand to be corrected by any of the two parties if my understanding is incorrect. Now, insofar my understanding is correct, I wonder whether the mental element needs to encompass all these elements on the factual side. More precisely, whether both the cognitive and the volitive part of the direct intent of an individual needs to encompass all these factual elements of the offence. And then, if this further is correct, I wonder whether the direct intent, or the mens rea, however you want to call it, can be inferred or presumed on the basis of actus reus, or the factual elements of the offence only, or does it require any further establishment by the courts examining the charge? And in case it is inferred or presumed to some or full extent, does this then require the defendant in such a case to specifically invoke error in fact or in law in accordance with Article 30 of the Turkish Criminal Code? So this concludes my question, and apparently also questions by the judges. Now the court will withdraw for 30 minutes. That is until 11:25. And then when we return, both parties will have an opportunity to briefly, but very briefly, comment on the pleadings of the other party and answer the questions of the judges. The hearing is thereby suspended.
La Cour.
Please be seated. The hearing is resumed. I call upon the representatives of the government to provide their brief observations to the pleadings of the applicant side and also to provide the answers to the questions put by judges. Please.
Thank you, Mr. President. I must say I haven't felt challenged like this since I did the Jessup Moot Court many years ago, so thank you very much for your challenging questions. We will not engage in a tit-for-tat of facts about this case. I think both sides have outlined the facts in their various pleadings. For us, the facts are clear and we maintain our position on the facts, so we will not respond. Thank you very much to Judge Raffatek, who basically provided us very helpfully with a list of questions, which makes our life easier. So regarding Article 30, Article 30 only applies once the prosecution has proven the intent of the accused, because the burden of proof is, of course, on the state. Once that is done, then the defendant must invoke it. There is no automaticity about Article 30. It will depend upon the circumstances of the case, also on the content of the defense. In our case, Article 30 would have not made any sense because the accused denied any involvement with the organization and denied the
You, Mr. Talman, there appears again to be a technical issue, and we apologize for this. Now, several colleagues are signaling that they can't hear you very well because the microphone possibly is. Can you check again?
I have a red light.
Okay, if you have the red line, this means that you have a green light. So please continue.
Okay. Otherwise, I can also speak up. I can fill a lecture theatre, so I will fill this room as well. So with regard to Article 30, that is the government's answer to question 1. the burden of proof is on the accused that he did not know of the violent nature. Now, how do you do this in practice? There have been cases before the Turkish court, including the Court of Cassation, where people have been acquitted because they could show that they did not stay in any of the houses of the organization, did not have any position in the organization, did not engage in any organizational activity, had no contact to other members of the organization, did not have a Bank Asia account, did not use any secret means of communication. So when this was established, then that was sufficient for the Turkish courts to then hold that there was no knowledge. So it was also used for the mental element. With regard to Article 30 and the layers, let me say at the beginning, although the applicant seizes on decisions of 2016, 2017, seizes upon layers, if you look at the decision of the Çorum Assize Court in this case, there is nothing about layers. You should take the decision of the Çorum Assize Court on its own. And there is also no question of jurisprudence developing subsequently. I think this case has to be evaluated on the basis of that very decision which we put before you, so you can see on what grounds that was decided. If we hypothetically engage in the question to what layers Article 30 applies, then according to the jurisprudence of the Court of Cassation, it would only apply to the first two layers. Now again, we have no decision by any court on what layer the applicant would fit in. As I said, these are individualized decisions where the layer of a person is not just decided on a single act or single fact, but the courts basically form an overall opinion on the basis of the acts and facts before them. Now, the government would say that a BBTM and ILCI would be in level 3 or 4, but definitely not in level 1 or 2. But this, of course, is the government's assessment. It is not the assessment of a Turkish court, because this question did not arise in the applicant's case. With regard to the number of BBTMs, and I'm always astonished by my colleagues who suddenly make 150,000 people in Turkey BBTMs. Again, the government has no clear facts on the exact number of BBTMs. After all, this was a secretive organization. But what we can say on the basis of the facts, there were 5 BBTMs in Çorum province, and there are 81 provinces in Turkey. So we are nowhere near 150,000. We are probably more in the range of between 500 and 1,000. But again, the government has no figure to present to this court. Acts, and the government would take the...
It appears to be okay. Please continue.
The government takes the position that all these acts, which we have listed in Annex 2 or in Document 2, which we submitted, all these 8 acts are as such lawful. But again, as I said before, we have to distinguish between the acts that are taken as evidence to prove the offense. The offense is not basically being a BBTM or being employed by a certain organization. The offense is membership of an armed terrorist organization. So the lawful or perhaps even unlawful acts are used to establish the offense of membership of an armed terrorist organization. But the acts used for that, the acts from which both the mental and the material element are inferred, may be lawful. And in this case, we have 8 lawful acts. With regard to the reference in the Yalchin-Kaya case, paragraphs 253 and 254, the government agrees with what is set out in these 2 paragraphs, and we take the position that it is a question of foreseeability. And for that reason, our presentation this morning solely focused on this question of foreseeability, whether it was foreseeable, not whether the organization had already been classified, because that was only done in 2016-17. But again, if I may say here, we always focus here on 2016. But of course, every legal case has a history. Every legal case has a journey. So if we look at the final instance judgment in 2016, there have been decisions in 2014, in 2015. There have been investigations that started in 2012. So only what we see is then the final decision. But that doesn't mean that there was no knowledge or that there weren't any decisions holding that FETÖ PDY is an armed terrorist organization. We have decisions from 2014 saying that FETÖ PDY is an armed terrorist organization. We just don't have a final decision by the Court of Cassation. That comes much later after going through all these instances. With regard to paragraphs 270-71, as I outlined before, the government disagrees with what is said in Yalchin-Kaya, that there is a specific intent requirement. There is no specific intent requirement under Turkish law. As I quoted the Court of Cassation, the intent, unqualified, neither specific nor direct, intent, it says, refers to the materialization of the elements in the legal description of the offense willfully and knowingly. So intent here is a shortcut for knowledge and will. There is no further requirement here. With regard to Judge Kitsakis' question about the duration of the detention in Unit F5, the government submits that the detention lasted for 13 months and 3 days. There is no record, at least no record available to the government, which would show how long the applicant slept or was forced to sleep on a mattress. What the government can say is that it is wrong to say that in the communal areas the lights are always on. The lights are off at bedtime also in the communal areas. With regard to the question of Vice President Jelic, I think I've already addressed that part when you asked about the legality of the activities. The government takes the position that the 8 different acts, that Social Security is paid, that you make payments into a bank account, are as such lawful acts. But again, as I said before, these acts are used by the courts, taking account of their diversity, continuity, and intensity to infer the material and mental elements. So, for example, if you are holding a certain position, if you are engaging in organizational activities, that helps the court to establish an organic relationship, or it helps the court to establish that the accused made a contribution to that organization, either in a moral or material way. And the same is true for certain acts like being in a certain position in that organization, that we can infer from a certain position that you have a certain knowledge that comes with that position. But of course, that is not seen on its own. These acts are taken together, and this is actually emphasized in the Çorum Assize Court's judgment 3 times, that the Çorum Assize Court evaluates the facts as a whole. They don't look at individual decisions, and each of you as judges will know that you are not just seizing on one act, but you are forming an overall picture of a case where many contributing factors finally lead you to your judgment. And the same happened here. With regard to the question about the reputation of the organization, again, I have addressed that before. Here we have, of course, to distinguish between the reputation of the organization in the general public and what the organization is like for the members who are privy to the objectives of that organization. And of course, this is not something special with regard to Turkey or FETÖ PDY. If we think about other terrorist organizations, say the IRA, ETA, the Red Army faction in Germany, before the first bomb exploded, many of these organizations were not known as terrorist organizations. But of course, the members that were planning and were instrumental in these subsequent acts, of course, knew very well long before the general public knew. And of course, as we have outlined in our written observation, because FETÖ PDI is a sui generis organization, basically that tried to basically take over the state by infiltrating the various institutions, including education, security, the police, and so forth. Of course, here we have the people involved in that, which have much earlier knowledge than the people who are actually part of the general public. But again, as I said before, even the applicant's parents warned him and said to him, get out of that organization after December 2013, as stated by the applicant in his submissions to the Chamber. I'm afraid, due to the time constraints, we do not have any direct response to Judge Felici's question, but we would be happy to provide you with a written answer if that is what you would like. With regard to the question of Judge Seibert IV, of course, that is one of the perhaps puzzling elements in this case, that we have both the mens rea and the actus reus, but it's not true that the actus reus is used to prove the mens rea. Again, the actus reus here is membership of an armed terrorist organization. Again, we have to distinguish between the criminal offense and the acts that help the court to establish that criminal offense. And of course, we have seen that the various acts of the applicant have been used, taking into account their continuity, diversity, and intensity, to infer both the mental element and the material element. So they have been used for both, But of course, the court basically looked at all of these and then formed an overall opinion. With regard to the question concerning hot and cold water in the prison, the government submits that there is cold water 24/7, so 7 days a week, 24 hours, there is cold water, and there is 2 days a week hot water for 24 hours. With regard to the President's question, the elements have been set out in Annex 1, and you can see in Annex 1 what the mental element has to cover. The mental element must cover is knowledge of the illegal objectives and that the organization uses or intends to use force. Now, if you want to change the constitutional order in a country, if that is your objective, and you will not achieve that through the ballot box, there are not many other ways open to you than to use force to achieve your objective. And of course, as we have seen from the statements presented by the government, from the leader of the organization, there is an element of force in those statements involved. So, the elements that are to be covered by the knowledge and will have been set out in our document number 1. And as I mentioned before, yes, the mens rea element is inferred. It is not presumed. There is a difference in criminal law, as you all know, between inference and presumption. And you can see that if you look at the decision of the Çorum court, but also of other Turkish decisions, these elements are inferred, they are not presumed. If something is inferred, does the applicant has to prove an error in fact or law? No, the applicant, as I said before, and the Turkish courts have acted on that, they have acquitted persons that could show that this inference was wrong, for example, because there was no organizational activity, no Bank Asia account, and none of the other acts that are present in our case. I hope I have done justice to all your questions. If not, I am very sorry about that, but we had only 30 minutes. With that, I thank you very much for your kind attention.
Thank you very much, Mr. Thalmann. And as for your request that you provide subsequently certain factual clarifications regarding the question of Judge Felici, you are entitled to do so in the deadline of 8 days. That information, of course, will be submitted also to the applicant side for any comments necessary. Okay? So now I turn to the applicant side to do their part.
Thank you. I will comment on the questions about Article 7, my colleague about Article 3. First, as a reply to the government's statements before, it was said that by the first intervenient that our client did not ask confrontation. We refer to the Annex 45, page 2 of the documents provided by the government. It is the interview of our client of 27 November 2017, where he says, the witness is lying and I'm prepared to confront him. And we refer also to the judgment where he repeats, I literally say, the witness is lying and I want to confront him. So we really, it's the government denies, but it happened. Secondly, to the question of Mrs. Rayford-Tag, I'm not sure that the name is correct, I'm sorry for that. I refer to Article 40 because number 40 of observations because I think it's some misunderstanding. What we say is that the new documents were not submitted to the judges before the appeal. They were submitted afterwards. And the proof of this, we went into the files, and that is what we describe in article number 40 of our observations. When the case came before the court, the Ministry of the Department of Human Rights asked, give us all the information of the file. And there came information from another file with 9 witnesses where also our client was mentioned. But these 9 witnesses' statements were never in the file. They were never in the file. And you can see that. We refer in number 40 to Annex 5, where you see the letters of the Department of Human Rights asking and the prosecutor responding that they were not in the file, but they found Mr. Yasak's name in another file that they did not continue, and they joined it to complete the file. But it was not in the file. I want to be very clear. The HTS, the second report about the communication has been added now for the hearing here, not for the second chamber. It was not in the second chamber file. That's what we have been saying. I also want to reply already. I will come back. In the beginning of his answer, our colleague from the government said, the burden of proof that he did not know lies on the defendant. That was been said. Actually, it says it all. I will come back on that. But that indeed is true. It is the defendant, it is Mr. Yasak, who has to prove the impossible to be proven, that he did not know the aim of the organization. I would like to ask you, if someone is asking you, prove that you did not know something. It is extremely difficult. It is extremely difficult. How can you prove that? I will come back on that. First of all, why the position is different. Judge Yüksel and also Mrs. Rafferda asked that. Because it's another procedure. We do not deny anything that Mr. Yasak has said. But we are here not in an appeal court. If I would start now to say what the court, the Chorm court decided, we do not agree on that, we do not agree on that, you would say, here, you're not in an appeal court. We have to take into account what the court of Chorm decided. And that's 5 elements. And on these 5 elements, we say, if you would take them for granted, which we don't do, but if you would take them for granted, it's not sufficient to have a conviction of member of armed terrorist organization. If we would do differently and say, Mr. Was not a BBTM, he had no code name and this on, you would immediately say, we are not in an appeal. And you would be right. We have to start from the basis which is the court decision, and as here pleading before your court, we cannot plead as if we were for the Turkish domestic court. And that's why we do that. We do not change anything that Mr. Yasak had says, but we need to take into account what has been said by the Chorm, and based on that, we say this does not give us. And that's why we have to give information. What does that mean, a BBTM? What does that mean, a code name? Otherwise, we, of course, can never claim that it was an unreasonable decision. Article 30 was asked in the Court of Cassation, number 2015, bar 2021-7, judgment of the Court of Cassation 21-10-2018, so from 2018, the Court of Cassation said, considering that the defendant may have acted under a mistake that could eliminate criminal responsibility, the application of Article 30 of the Turkish Criminal Code must be evaluated by the court ex officio. That's a decision of the Court of Cassation from October 2018. We gave the reference number, so the case number is 2015, bar 2217. So That's the first. Did he need to invoke Article 30? No. However, in his deposition to his interview to the police, he clearly stated, he was asked, and he said, I did not know the aim of the organization. That is the deposition he made before the police, and he repeated that, I think, before the court, but I could not confirm that. But anyhow, in his interview, which is part of the files, he said, I did not know the aim of the organization. If it is ex officio, and he said he did not know, why should he then, in his defense, where he say, I was not a member anyhow, why should he all the time insist on Article 30? That is his way of defending, he has the right to, and the court should have examined that clearly. I come back on this element of Article 30, and several judges, you will excuse me that I do not address you separately, have asked about that. There are 7 levels, says the Court of Cassation. The jurisprudence is that for the level 1 and 2, it can be reversed. But for the level 3 to 7, it cannot be reversed. This is somehow contradictory to Article 30. When the Court of Cassation constantly say it cannot be reversed, the fact that you knew and that you wanted to contribute, when you're in the 3 to 7, how then can you use Article 30 in an efficient way? And we know it has been nearly never used. We know from a court decision, cassation, who has been given by the government in the follow-up of the Helsinki case for the Committee of Ministers, where a person of 16 years, I think, was given Article 30 because they said he could not know. That's one explication we once found with Article 30 in a person of 30 years, of 16 years, excuse me. And secondly, we have knowledge of one where a judge was in trial, and it is quite cynical. They said Article 30 we accept because after 2014 he was actively campaigning in the elections for judges on the side of the government candidates. I don't have it with me, I know it by heart, I can send it also, I can send this decision to you, where they take into account what he did afterwards in the campaign of the judges. But otherwise, Article 30 is nearly never used because it's clear. 3 to 7, it is automatically you know and you want. And I take notice of the fact that the government has to admit that the level has not been mentioned. We don't know. Rightly you said, we don't know. The government now thinks 3 or 4. Yeah. If you condemn someone, you should know, and you have a court decision of the Court of Cassation and the Constitutional Court who says 1 to 7, at least you should have objective criteria. One of the elements of criminal law is that it's an objective what you do and for which you are condemned. So he's now condemned because a hierarchical position between 3 and 7, something like that, we don't know, perhaps 3 to 4. As such, this is quite a very extraordinary element to say.
Mr. Hermes, I'm so sorry to interrupt you just for a second. You have taken now half of the time that the government has taken, and you are still at the questions of Judge Nierefferty. I know that you referred also to some other questions. I would still invite you to concentrate a little bit more to the point of the questions.
Yeah. Judge Guimard, who said, are they legal? The government responded. Mr. Judge Legis said about 2010 to 2014, what the government says, you could know because of the judicial actions. We don't see that as an element of information. And from the NSC, which only occurred in 2016 and later. I will close it because I want to respond to your question still. In the jurisprudence, the knowledge about terrorist organization, one element, because you said, do they have to know that they are armed? I think also in the jurisprudence of the court, the capacity of the organization to execute terrorism is an element. You cannot evaluate an organization as terrorist. You have the aims, but it must be reasonable that they can execute. When some lunatic says, I will overthrow the state, and two people go with him, it will not be an organization of terrorists because they cannot. And I think, but I have not, I didn't found it, I must excuse for that, but the capacity to do it, so having the arms, you have to know that they also can do it. If you have knowledge, no knowledge that they could do it, then one of the elements of knowledge is not fulfilled. And now I give my colleague for Article 3.
The President, members of the Court, I will now address the questions that were asked by Justice Xitakis, Drovic and Felici on Article 3 of the European Convention. So just to clarify it, our clients state first only in the F5 section, where he stayed for 14 months. Of these 14 months, he slept on the floor for 4 months. Then he managed to secure a bunk. He slept in a common area, which in L-type prisons is an area that has always, for security reasons, the light on. We just checked with the client, he confirmed the light was always on for these 4 months. And he stayed there in that area, or in a cell section eventually, with 37 till 47 inmates, while the capacity is normally 7 detainees. We have explained that in our submissions. Then he was moved to the F10 section, where he stayed for more than 3 years. There, he slept for 10 months on the floor before he managed to secure a bunk. So in total, he slept for 14 months on the floor before he managed to secure a bunk. And in the F10 section, it was the same system, but there they stayed with 27 till 42 detainees. And then, as to the question whether that would lead to an inhumane or degrading treatment, I think it's also important to take into account, we have developed a lot of arguments in our submissions, but the aggravating conditions in that regard. The fact that he had to sleep on the floor, the fact that the light was on, the fact that there was constant supervision, no privacy, the fact that they had 2 showers and 2 toilets for around 40 people, combined with water shortages, and the fact that they only had warm water for 2 hours, 2 times a week for all these 40 people, which means that in reality you have, we calculated it, maximum of 7 minutes a week to take a shower per person. And in general, that was often not even possible due to the water shortages. And that then combined with the fact that there was hardly any place, that's also in the concurring opinion of Judge Krensch before the second chamber, hardly any space to move, to sport, to do anything else but sitting in a prison cell. And most of the times, at least until July 2018, all sports, educational activities, etc., were not taking place, were cancelled due to this massive overcrowding of the Turkish prisons, due to the thousands of people that were put in prisons. And eventually and finally, but this is also a crucial element, there is a fact that there were very high temperatures during the day, around 30 degrees, no air conditioning, so many people in a very narrow space together, and it became very cold at night, 8-9 degrees, again in such barbaric or hard circumstances that is not something that would lead to humane treatment. And therefore we think that the two things combined, the minimal space as we developed in our submissions with these aggravating circumstances, that would lead to a violation of Article 3 of the Convention. In general, because we have now been citing a lot of numbers and also some facts and some new sources which we have not managed to include in our submissions, we would also like to submit a brief written note to bring these factual elements in response to the questions of your judges to your court and make it a bit easier in your deliberation. So we will also, if your president would allow us, follow the same time frame as the government. I thank you.
Yes, thank you so much. I can confirm that equally 8 days can be given to the applicant side to provide us with the information that you are not in possession of right now. However, this needs to be strictly respected. And again, as for the government side, this will be shared to the other side for any observations. So I thank both parties for their replies, and I turn to my fellow judges, those who ask questions, whether they wish to have further clarification on any point already asked. I see Judge Neer Rafferty. Yes, please.
Very short, and it was overlooked, I think, but it should be non-controversial. The question that I did not write down, the status of witness statements who did not give evidence. What is the status at the trial, first of all, of a witness statement where the witness never gave oral evidence? And what is the status of a witness statement, not a report, not the HTS report? What is the status on appeal of a witness statement that came in after conviction but before the appeal judgment was handed down? Thank you.
I think this was a question for the government side. Am I correct? For both sides. So both sides are invited, if they so wish, to provide further clarifications if they have the answer ready on the spot.
Now? Yes.
We can hear you. Okay. Please go ahead.
Thank you very much. First of all, I would put on the record, because it has been distorted quite a number of times. There were 2 witness statements before the Çorum Assize Court which were given to judges by AB and YB. And there were 5 investigation statements in the file at the time the Çorum Assize Court took its decisions. And we have mentioned the various names before. And we can show, because the applicant responded to all those 5 statements that were given to police. So they were known to him and responded to him. Now, if you look at the minutes of the hearing which we submitted to you, you will see that in the hearing it is said that the whole case file was read to the applicant in open court. So he was basically confronted with the witness statements. The government, according to the Code of Criminal Procedure, submits that these witness statements can be taken into account by the court, and the applicant had the opportunity to respond to them and responded to them. If you look at his defense statements, he responds also to witness statements that are later on not mentioned by the court. With regard to the general practice in Turkey, once a case has been decided by the first instance court and it is then appealed on accounts of fact and law, new evidence will be added to the case file, because the appeal court will decide the case on facts and law. And that is why the government submitted as the various documents the letter that were sent to the Samsung Regional Court, showing that three more witness statements were added at that stage. And so they were before the Samsung Regional Court, and we submitted the documents where you can see the signature of the judges, taking them into the file so that you see that the judges were aware of these statements when they decided on appeal.
Thank you so much. Would the applicant side wish to take the floor on this issue?
Yes. 1 minute, please.
Yes, I think we can hear you.
You can hear me? Okay. It's okay?
Yeah.
Yeah, okay. Yes. I also forgot one question I will shortly answer, but this one, and our observation is that when there is new elements, indeed at the appeal court, it can be taken in account on the condition it is contradictory. That, of course, the defendant can't defend himself against it. It is our strong conviction, we refer to the documents that we have made, that this new information was perhaps, we don't think so, but we will not discuss that too much, that it was not presented at the appeal stage to the applicant, to the defendant. So he had not a right. And I think there is no discussion that there was no material at the appeal stage that it should be submitted to the defendant. And I did not respond to your question about the numbers. We never said there were 200,000 BBTMs. We said there were 200,000 students. I refer to Annex 11, where we calculated based on the information of the Ministry of Education, where we made an extrapolation from Çorum, like our colleague did, knowing, of course, that Çorum is a small province. We made an extrapolation in 2 ways, and it's Annex 11. I did not respond. I apologize for that.
And briefly, so your first question regarding the oral statements and the fact that you need to contradict them as a key witness. So that is a general rule in Turkey, according to our understanding, that normally speaking, witnesses are heard in a confrontational manner in court. And this is confirmed by the government that this happened for 2 witnesses, A, B, and B. But what is also important in that regard is that our client, and that's also resorting from the minutes of the hearing before the Assize Court, is that he asked for a confrontation. He said, I want to challenge this discussion because I don't agree with their witness statements, and he never received that right, that possibility to challenge the witnesses. It is also the fact that in his procedures he also raised Article 6 of the Convention issues, and that notably concerned also that issue of the inability to challenge the witnesses. So I think.
Thank you so much. I see that Judge Đurović also would like a further clarification. Again, patience is... No red light yet?
I can also speak without.
You speak up, yeah.
Thank you, Mr. President. Just in line with the question in relation to the conditions, because we could see that one of the challenges of detention in the prison was that it was made to kind of have up to 500 prisoners, and at one moment, because of the coup d'etat and many arrested persons, it ended up having almost 2,000 people. My kind of follow-up, my clarification of my question would be, what has the Turkish state done to kind of secure equal level of, respect of human dignity and rights and privacy to the prisoners, despite the fact that the number that actually the prison itself got kind of really overcrowded up to 5 times to its original capacity? And that was also connected with the question of the water supply. Thank you.
This is specifically directed to the government, so it will only be the government responding to this.
And the government respectfully asked to submit the answer in writing to this.
This, of course, will be granted. Any further requests for clarifications? Not new questions, just clarifications? This does not appear to be the case. Thereby, we have come to the end of the hearing. I thank the parties for their submissions and answers to the court's questions. The court will now deliberate on the case, both on the admissibility and the merits. The judgment will be delivered later. The parties will be informed of the date of delivery. This concludes today's hearing, and I declare it closed.